In FCC versus Pacifica, Brennan noticed in his dissent, if you don't like what you hear on a radio station, you could turn the radio off or switch the channel, like on television, like on YouTube, like on any place else. You look through a magazine, you turn the page. If you don't like what you're reading, you look for something else. Well, I wish that I could have turned off the basketball game, the live basketball game, taking place in an area 16 feet wide between two-story residential properties in a single-family residential district, one of those properties being mine. The sound permeating all areas of the interior portion of the property so that it could not be used while the game was going on. Can't adjust the volume, can't turn it on and off. Captive audience. It's a deprivation of property rights. Well, while this case was pending as a Monell action in federal court, I decided to become an educational broadcaster at SUNY Binghamton. The educational broadcasting license issued by the FCC is held by the university. All of the station property is owned by the university, exists on campus in a university building. The people that work for the radio station, such as the general manager of the station, receives money as an employee of the university. Even in the event that they go this other route, which I'll get into a little bit later, and say, well, it's the student association, the student assembly or whatever, where they get the money from. The student assembly gets its money from tuition. So it's impossible to say that the student assembly is somehow a private enterprise separate from the university, which was the eventual ruling, or part of the eventual ruling in federal court. But anyway, aside from that, the facts regarding the case are undisputed. There is a express policy by WHRW FN Binghamton, New York, which prohibits indecent speech and profane speech 24 hours a day. This has already been ruled as unconstitutional by the U.S. Supreme Court and in the Second Circuit. So there was no question that the policy was unconstitutional. It was alleged that I had aired a sound recording at 4 a.m. containing the word shit, and that this is an obscenity, as alleged by the students running the radio station. Now, this is another aspect of redefining things. In the FCC Pacifica case, it was decided that indecent speech was comprised of certain things. I don't have the definition memorized. You could look it up on the FCC site. But it's like, you know, words like shit, piss, is considered indecent speech. I would go on to say that all speech is considered to be indecent speech at most. I don't know that anything is actually obscene speech. I don't see that there's any kind of cases that say that certain words or content or whatever is obscene. But these college students took words and content and context that was clearly constituted indecent speech or profane speech and merely redefined it as obscene. and therefore said that, well, you can't broadcast obscene speech at any time, so it's banned 24 hours a day. Even though the Supreme Court says indecent and profane speech is protected, according to these college students, no, you can't do that. So what the case turns on is whether or not these college students are state actors. And according to express New York State rules and regulations, the president of the university is responsible to ensure that the broadcast policy of college radio stations established on state university campuses, public state university campuses, are lawful. And this was something that the university president, then Lois DeFleur, refused to do. So on the one hand, you have these college students that are saying that various words are obscene, that indecent speech is obscene speech, that profanity is obscene speech, and that none of this can be broadcast at all, ever. So I was removed from an on-air, a live on-air broadcast on the instructions of the general manager of the station by campus security officers. And clearly those officers are state employees. So the whole act is state action. And it's based on a policy, a broadcast policy that's been instituted by the radio station, which is owned by the state university. It's paid for by the state university, funded by the state university. The equipment is supplied by the state university, the room, the building, the broadcast mechanism, everything. So it's a state policy action that violates my First Amendment rights that are incorporated against the state by the 14th Amendment. It's a very straightforward case. The policy should have just been struck down as unconstitutional. But Andrew Cuomo, who was then the Attorney General of New York State, didn't want to do that. So they made a technical issue out of the 11th Amendment and the caption of my complaint. Now, under state law, the caption of my complaint, which named the university board, failed to name the name of the university president, who was also part of the board. Now, according to the federal judge, this absolutely cannot, under any circumstance, be amended. And the Second Circuit refused to hear my appeal, even after I paid for it. The other aspect of it, which is pertinent to my points in this series, regards this idea that, according to the federal judge, on his own motion, that the radio station is somehow a private enterprise and therefore is governed by Rehnquist's ruling in Blum v. Uretsky, and that this is private action, that the university has absolutely nothing to do with the radio station, the broadcasting policy, or anything else. So the express rules and regulations in New York State were ignored. The duties and responsibilities of the university president under rules and regulations in New York State were ignored. And her duties and obligations were essentially abdicated or illegally delegated to a student, an employee, another employee, along with the security officers. And the attorney that was hired by the college students claimed that the radio station itself cannot be sued or cannot even be named in the complaint because it's an assembly. It's not a corporation. Now, there's rulings in New York State that say that if you have a situation like this and you mistake the assembly or the free association, I guess it's what it's actually called, if you mistake the association for a corporation, if the association has characteristics similar to a corporation, it's considered to be a corporation. In any event, an association is supposed to contain the names of the various individual members of the association, the board, which is the same as a corporation. It's just, for some reason, deemed to be an association. It's not formally incorporated by the county or whatever, or the state. And there's issues with that, whether a college radio station that is regulated by the rules and regulations in New York State, that is established on the campus, is in fact incorporated into the university and into the state. But according to this judge, no. So this is something to bear in mind, because people that are against this idea of corporations, we don't like the idea of corporations having the rights as persons or recognized as persons for particular purposes under the law, like to be sued, to own and sell property and things like that. What comes after a corporation, or the only alternatives, are assemblies and associations. And associations are dealt with very similarly as corporations are. So one of the things is there's really no way to escape this relationship. The other aspect of it that's pertinent is why, in this day and age, would college students decide to say that various words like shit, piss, fart, tits, whatever, cocksucker, fuck, why would they say that these words are obscene and can't be broadcast? Somebody had to pressure them into doing that. Now, the FCC doesn't pressure them into doing that because they have the safe harbor zone between the hours of 10 p.m. and 6 a.m., where indecent and profane speech are allowed to be broadcast. So why, or how did this happen? Well, there was a liaison that in fact submitted an affidavit on behalf of the university president and board, who arguably, according to them, did not appear, even though this person submitted an affidavit on their behalf, which I objected to, and the judge refused to entertain or accommodate my objection. Now, it's very possible and suspect that this person, on behalf of the board or the president, told these students, look, I'm not telling you what to do, but, you know, Tommy here, he's a 56-year-old man, well, I was 54 or something, and, you know, he's hanging around with you kids at a college radio station. Is that how you want to be when you grow up? When you're 50 years old, is this what you want to be doing? Or do you want to get that paper so you could get a good job and make the bucks, get the bucks? I'm not telling you what to do. Just make sure you do the right thing. Don't screw up. Don't screw it up, because, hey, you're going to be strapped with this debt anyway. So you might as well get the paper, if you know what I'm saying. Like I said, I'm not telling you what to do. Just make sure you do the right thing. Something like that had to happen. And the Andrew Cuomo and the college university and the district court judge, Tom McAvoy, everybody that was involved in the whole thing just completely covered it up. The local newspaper refused to report the case. No media, national or international, would take the case, would report it in any shape, way, manner, or form. It was completely and utterly swept under the rug, okay? Now, this was not a Mon-El action, but what is significant here is a case called West v. Adkins, which was decided after Blum v. Uretzky, that involves the actions of state employees.